Welcome back after the break, ladies and gentlemen. We will carry on now looking at POPI, the Protection of Personal Information Act. Please note that POPI is not effective yet. However, we do think that the effective date will be in the near future since they have appointed the information regulator recently. Just a bit of background on the POPI Act and when it became effective. The Act itself was gazetted on the 11th of April 2014. And certain sections within the Act already became effective at that date. The sections that became effective was really the administrative sections. Section 1 dealing with the definitions, Part A of Chapter 5 dealing with the fact that they have to establish an information regulator and what the powers of the information regulator would be. Section 112 and 113 dealing with the fact that the ministers may make regulations and the procedures for making these regulations. So really all of the rest of the sections that deals with how a company should process personal information is not effective as of yet. So what is the implementation process going forward? In April 2016, they did shortlist candidates for vacancies on the information regulator. Then in May, they recommended Pansy Tlakula, the former IEC chairperson, for the chairperson of the newly formed regulator. The recommendation was approved by National Assembly, if I'm not mistaken, on the 7th of September, somewhere in September, and they were appointed. So Pansy Tlakula was appointed, and they also appointed 4 other members to the information regulator. What that means is that they now only have to draft regulations, allow for public comment, and then we will have an effective date. However, we do not know when that will be. We are still waiting to find out. We are still waiting to see. All wait in suspense. However, once the Act is made effective, companies will have a year grace period to comply with it, to ensure that their businesses and their documentation and their record-keeping capabilities is changed in order to comply with the provisions of this Act. Please note, it is our recommendation that a year is not enough unless you are a very small company to try and get everything together to ensure that you comply with this Act. So early implementation is necessary. You already need to know what is the provisions of this Act and how are you going to implement this Act in your business. Otherwise, you might have issues in future. So in order to understand what this Act means, we have to look at the definitions first. This Act is all about processing personal information and how should companies process personal information. Why did this Act come into effect? South Africa isn't the first to have this Act. A lot of other companies also have data protection laws and data protection acts. So it's really not a new thing. It's not that our government is suddenly being funny and they want this in place. We're just keeping up with global legislation and global growth. So this Act is really there to ensure the right of privacy for individuals, to ensure that people know who has their information and people can protect their information ultimately. The point of this Act is to try and identify, do you have personal information? And if so, do you process that personal information? And if so, you should do it within certain limitations and certain boundaries. So let's start with looking what is processing. When will you be processing information? It's when you collect or receive information and then you record that information, you organize it, you store it, you update it, you modify it, you use it for any reason, and in the end you erase or destroy it. Any one of those is seen as processing. If you do any one of those to information, you are processing it. If you are not merely only viewing information, but actually using it, storing it, recording it, you are processing. What is personal information? This Act only applies to the processing of personal information. Personal, you can read through the definition. It includes anything about the data subject such as race, sex, ethnic or social origin, sexual orientation, culture, language, education, employment history, ID number, email address, telephone number, your contact details, blood type. If we go to the next slide, personal opinions, views or preferences, any correspondence sent by that person of a private or confidential nature, and the views or opinions of another individual about a person. So it really includes quite a lot. It's a broad spectrum of information, but it's really information applicable to individuals. And if you think about the contact details, information applicable to companies. The type of information that you would like to keep private. The type of information that isn't for public eyes and is not necessarily necessary for people to know. Then you have special personal information. And why do they differentiate? For special personal information, you need consent. You cannot process special personal information unless you have specific consent from the data subject to do so. What is special personal information? Any of your personal information, so the things we have seen above, of a child. Any information of a child who is subject to parental control, anyone under the age of 18 years. And then for anyone who's not a child, special personal information would include your religious, philosophical beliefs, race or ethnic origin, trade union membership, political opinions, health, sexual life or criminal behavior. And you are not allowed to process this information without specific consent from that person. Of course, there are some exceptions, such as your health. Your doctor is allowed to process your health information. They need to do it for their job. In terms of your trade union membership, the trade union of which you are a member can process your trade union membership details. In terms of your religious beliefs, your church which you belong to can process your information. So there are certain exceptions to this, however they are few. Let's quickly look at an example. Within this relationship, this information relationship, you have three parties. You have a data subject, which is the person on whom you receive the information. Then you have an operator and a responsible party. A responsible party will be the person who records and receives and uses the information. So if we look at our example, let's say you are an employer who receives CVs from candidates, you will then be the responsible party. You receive the information. You use the information. The candidate, the person who gave you the CV, is the data subject. If you use a third-party service provider to process the information on your behalf, that third party then is the operator. And the operator has certain things. He cannot just do with the CV whatever he wants. He needs to perform his duty in terms of a contract with you as responsible party, in terms of rules that have been set up beforehand in terms of this contract. Cannot just sell that information or do whatever they want with it. So what does this now mean? Let's quickly just sit down and think about this. Every single business in South Africa will have to go and sit and identify, do they process personal information? And I'm sure the answer will be yes. Think about it. You have employees of whom you have ID numbers, contact details, things like that. You have customers of whom you have addresses, email address, ID number, maybe not ID numbers, telephone numbers. You have suppliers of whom you have details. So every company will have to go and sit and think, who do I have personal information of? Who is my data subjects? Am I a responsible party or am I merely an operator processing this information on behalf of someone else? Because if you are a responsible party, you're going to have a lot of responsibility. A lot. So let's quickly look at your responsibility. The very first one in terms of the POPI Act says that you have to be accountable. You have to take accountability for information that you have. It's the responsibility of the responsible party to ensure that they protect personal information. How are they going to hold you accountable? Well, number one, there's quite hefty fines. If you are found guilty of contravening this act, you can get a fine of up to 10 million rand or 10 years in jail for your representatives such as your company directors, your compliance officers, your information officers. Quite high penalties. Also, you have to report breaches of personal information. You have to tell people, listen, I lost your information. So there are a bit of reputational damage you can suffer as well. So we do not want to ignore POPI. We need to take immediate action to address its requirements. Then the Act starts with the limitations. The limitations in terms of how can you process information. Now that you've figured out that you are a responsible party and you have to process information, what can you do? And the very first limitation is based on 4 conditions. First one says that your processing should be lawful. You cannot steal another's database. I think that goes without saying. Secondly, you should only collect and process as little information as you need for your business purpose. So you need to impose minimality. If you do not need information, do not ask for it. What does that mean? You'll have to go and look at your documents in which you receive information, your contract with your employees, the information they provide, the information you get from your customers or from whomever, and ask yourself, the personal information that you require on that document, do you really need it? If not, then you shouldn't ask for it. You should take it off. The third one there, consent, justification, and objection. If we look at consent, you need consent from a data subject before you can process information. If you don't have consent, you're not allowed to process it. You're not allowed to use it. You're not allowed to record it. You need consent. Consent can either be through they actually gave you the information, so by them giving it to you, they give consent, or you got it from someone else and you called them and you ask, can you use it? But you need consent. There are some instances where you don't always need consent to use the information, such as if you need to report in terms of a law. You need to report in terms of FICA. Then we're not going to ask people, listen, I need to report to FICA, may I? FICA says you have to report. So in that instance, you don't need consent to process the information for that purposes of the act that you are complying with. Secondly, if you're going to protect your legitimate interests, you're tracing a person to collect outstanding money. You don't have to get his consent. You can give his number to a personal investigator, private investigator. You can do that because you're trying to protect your legitimate interests. Justification, the burden of proof is on you as responsible party that you have consent. You need to prove that you have consent. Objection, the data subject can object to you processing the data. They can call you and ask you to stop, to delete the information, or to correct information. And then the last condition there is that you need to get information directly from the data subject. Directly from the data subject. Unless they made it deliberately public. They went on a public platform such as Facebook and said, listen, here's my number, here's my details, here's my religion, do with it what you please. Then of course they made it public. You can take it then, but you still need to get their consent to use it. There's some other exclusions, such as if you need it in terms of an act, or if you're not going to cause injury to the data subject's legitimate rights. Our second requirement is purpose specification. This personal information must be collected for a specific, explicitly defined and lawful purpose, for a business reason. And that information can only be used for that specific, explicitly defined reason. You should also take reasonable steps to ensure that the data subject is aware of the reason. So what does that mean? Every time now that you are collecting data from a data subject, you have to tell them, listen, I need your data for this. I am going to use your data to find you a job. I'm a recruitment agency. I need your data to find you a job. And then you can only use it for that reason. You can't use it for anything else, direct marketing, whatever else you want. Why do we do this? So that if you provide your information to a company, you know exactly why. Why do they need your information? What are they going to do with it? And if you don't like that reason, you can at least ask them to stop. The other part of purpose specification is retention of the documents. How long are you allowed to retain these documents, to retain this information? And the Act says only for as long as necessary to achieve the purpose for which it was collected. Unless, of course, there's another retention period under an authorized law. But now the problem is, we have so many pieces of legislation that tells us how long to keep information. National Credit Act has its own, FICA tells you to keep it for 5 years, Companies Act tells you to keep it for 7 years, CPA, the Consumer Protection Act, tells you to keep it for a period of time. So it's going to be an administrative nightmare to try and go and sit and figure out which act tells you to keep your information for how long, for what type of period, and which information do you not need to keep in terms of an act. It's going to take hectically time to sort that out, and then to categorize the information in the different categories, and to try and control that information and delete them after that period of time. So the Act also says if a retention period has been consented by a data subject, you can use that retention period. So my advice is, in your terms and conditions, just say, listen, I'm going to retain this records for 10 years. The data subject consents to the terms and conditions, you're good to go. Now you can keep the records for 10 years, no matter what any other act says, and after 10 years then you can destroy it. And then it's only one period that you need to worry about. I'm saying 10 years because then it'll be longer than any of the other acts. You can make it another period. You can make it 7 years, since the Companies Act says you need to keep documents for 7 years. Your next requirement is limitation of further processing. This requirement states that we already said you have to get information for a specific reason and you cannot use it for anything else. So let's say now you receive personal information from a third party and you pass it, or you pass information on to another party for further processing. You have to make sure that that further processing is compatible with the purpose for which it was initially collected. Because we are not allowed to process information for any other reason than the reason that you told the data subject about. So just to give you an idea, if you are an estate agent and you get details from a client who wants to buy a house, and then this property needs to be registered with an attorney, you are allowed to give the information over to the attorney for further processing, because it's for the same reason. It's compatible with the same purpose. It's still to buy the house, to register the house. However, you cannot give that information over to your buddy who's a painter or an interior decorator to go and call this person to go and decorate his house. It's not for the same purpose. Further processing will, however, be allowed in certain circumstances. So in certain circumstances, you can do something else with that information. Number one, where you have derived the information from a public record. That person has put his information on Facebook. Unfortunately, if you put your information on Facebook, you basically tell people, here's my information, do with it what you like. There you go. Secondly, maintenance of a law or to comply with legislation. We already talked about this. If you have to report, let's say in terms of FICA, to the FIC Center, then the POPI Act does not apply. You have to report. You don't have a choice. If the further processing is to prevent or mitigate a threat to public health or safety, or the life or health of the data subjects. For instance, your employee slips and falls at work, cuts open his head, you rush him to the hospital, and now the hospital needs personal information. You are allowed to give that personal information. If it's for historical, statistical, and research purposes, and the information is not in identifiable form, for instance, you do a nice statistics research to say 20% of my employees is 20 years of age, 10% of my employees is 30 years of age, 50% of my employees is 40 years of age. That is allowed. And lastly, if the information regulator grants any exception, which of course none have been granted yet, since the information regulator was only established recently. Then you have to ensure the quality of the information. You have to take reasonable steps that the information is complete, accurate, and not misleading. So, on a regular basis, just find out if all the information is still correct. The next requirement of this act is openness. You need to make sure that you are open with the data subject. You have taken reasonable steps to ensure that the data subject is aware of the fact that you are collecting his information. He is aware of the name and address of the responsible party, who has his personal information, for what reason, the purpose for the personal information, whether or not the information is applied voluntarily or mandatory, the consequences should he fail to provide the information, if there's any law authorizing or requiring the collection of the information, and if you intend to transfer that information to any third country or international organization, so that he at least know, will he have protection if his information is transferred to a third country. What is the reason that we need to do this? Well, because there are a lot of instances where information is received not directly from the data subject, where in a group of companies you exchange information, where you get information from business partners, where you get information from Facebook, so on and so forth. And every data subject has the right to know who has his information. I'm sure you would want to know who have your information. So every person has the right to know. And for this reason, you need to give this notice or make sure the data subject is aware of it. The Act doesn't give any guidelines in terms of how are you going to tell people that you have their information, especially where you received it from someone else or from a public platform. But we're hoping in the regulations that they will give some guidance. The last requirement then in terms of this Act deals with security safeguards. And it says that now that you have the data, now that you have processed it, you have to make sure that you guard this data against loss or against unauthorized access. How do you do that? Well, identify your risks. What is the risks that your information might be stolen, that your information might be damaged, that your information might be lost? Things like it's saved on a network, someone can hack the network. It's saved in the cloud, someone can hack the cloud. It's on a laptop, someone can steal the laptop. It's on a memory stick, someone can steal the memory stick. And what are you going to do about it? Now you need to establish safeguards. How am I going to protect this information? I'm going to put on antivirus. I'm going to put on firewalls. I'm going to lock my computer with a password. Things like that. And then of course you have to verify that these safeguards are actually implemented, maybe through policies and procedures, and you have to update these safeguards continually. Here's a list of some safeguards that you can implement: access rights, physical access controls, computer passwords, firewalls, encryption, antivirus programs, exit processes. Just a few of the things that you can implement to ensure the data is not stolen. And then when you do find that an unauthorized person has required access to information or information has been lost, you have to notify the regulator and you have to notify the data subject. So this is really where the problem then comes in, where you have to notify the data subject, email them, call them, put a advertisement somewhere on the website, somewhere in the news media to let people know that you have lost their data. And this will really cause a big reputational damage to your business and to your company. And then if the regulator comes and inspects you and see that you didn't comply with the act and that's why you lost the data, you can now also get penalties. The last requirement of the act says then that the data subject has a right to participate and to request any responsible party to confirm whether or not they have information on him. And what is the information? If it's not correct or incomplete, to update the information, or they can ask you to destroy and delete the information. And you have to give that information and you have to delete the information as requested. So very important, if you look at Poppy, it's really going to have a big impact on companies. You're going to have to think about your policies and procedures. How are you going to change it? How are you going to change your documentation to make sure that you get consent, to make sure that you only get the personal information that you need? How are you going to control your data, make sure it doesn't leak out? How are you going to safeguard it? All of those things. A lot of things to go and consider. So important to start considering it immediately. Next, we move on to the Labor Relations Act. Please note there really wasn't any changes in terms of the Labor Relations Act. We're just looking at it because recently, of course, we've had a lot of CCMA cases where employees are winning because employers do not follow the correct procedures when dismissing employees. So what happens is that they dismiss the employees for the right reason. However, they do not follow the correct procedure in dismissing the employees. And then the employees actually have a foot to stand on. They take them to the CCMA and they win their cases. So let's quickly look at the requirements of the Labor Relations Act. The Labor Relations Act really deals with how can you dismiss an employee and when will it be a fair dismissal, because it is the right of every employee not to be unfairly dismissed and not to be subjected to unfair labor practices. What is seen as a dismissal? Let's start there. When will you be dismissed? Please note the burden of proof is on the employee to prove that he was dismissed. So the employee first needs to prove that he didn't resign or didn't leave or didn't dross from work, that he was actually dismissed. The moment the employee can prove it, then it's up to the employer to prove that the dismissal was fair, that the employer followed the correct processes and procedures to dismiss this employee. What is seen as dismissal? When can an employee say that he was dismissed? Well, when his employment was terminated with or without notice. If the employment was terminated by the employer, then it is a dismissal for whatever reason. If this person was in a fixed contract and the fixed contract was not renewed or it was renewed on less favorable terms. So you didn't renew the fixed contract or you renewed it but with less favorable terms. However, for that one specific section, the employee has to prove that he had a reasonable expectation for the contract to be renewed. So let's say you are on a contract to build a ship and the ship is done, it's built. You do not have any expectation to get another contract. The ship is done. However, if you can prove that there was an expectation created, your contract has been renewed for the last 10 years, there's still a lot of work to be done, you can prove that there was an expectation. Without an expectation, it's not a dismissal. It's just an end of a contract. Third one, if you went on maternity leave and you came back and you no longer have a job, or they dismissed you because you are pregnant. Fourth one, the company had to retrench people and after they retrenched people, they re-employed new people, and you had an agreement with them to be re-employed, but now they don't re-employ you. So in terms of a retrenchment agreement, you had an agreement to be re-employed should the company want to employ anyone new, and they did not re-employ you. And then lastly, your constructive dismissal, when your employment was made intolerable. However, then you once again have to prove that you left because there was no alternative. The employment was made intolerable. Now, if you want to dismiss a person, you can. We're not saying you can never dismiss a person. You can. You can fire a person if you want to. You can dismiss a person. But the dismissal should be substantively and procedurally fair. There should be a reason for it. You should be able to substantiate it, and you should do it with the correct procedure. Now, in terms of substantive reasons, there's really only 3 statutorily recognized grounds for dismissing someone: misconduct, incapacity, and operational requirements or retrenchments. If it's not for one of those 3 reasons, you cannot prove that it's for one of those 3 reasons. You have already lost. Procedural fairness depends on the reason why you are dismissing someone. So we're going to go through it now. We're going to look at each reason. What is the procedure you have to follow to dismiss someone in terms of that reason? As we said, the employer should prove that the dismissal was fair. So the first thing you need to know in terms of if you want to dismiss someone is that you should have proper disciplinary procedures. Adopt disciplinary rules that establish your standard code of conduct, that tells employees what they should do, that is clear and available to all employees, to correct their behavior through a system of disciplinary measures. So have some procedures in place to deal with misconduct, such as counseling or warnings first. And it should be progressive. So it should start with a warning and then a written warning and then maybe training and then a final warning and then dismissal. We do not dismiss just for the first case, just for the first problem. So you should have a proper procedure. If you have it, it already strengthens your case. To say you went through your own disciplinary procedure, this is what your rules are, and you followed it. So start with warnings. If it's more serious infringements or repeated misconduct, maybe you can give a final warning. However, dismissal, reserved for last case scenario or serious misconduct. Serious misconduct. Let's look at dismissal due to misconduct. Now, you have to be able to prove on a balance of probabilities that misconduct has actually occurred. You need evidence to the fact that misconduct has occurred. Misconduct in and of itself will not automatically always justify a dismissal. You have to ask yourself, is dismissal appropriate? And that it is decided on the nature and seriousness of the misconduct. That misconduct must render the employee unfit for employment, or the relationship of trust must be broken for you to dismiss him. Now, the things that they are going to consider when this is brought before the CCMA is, number 1, whether the employee contravened a rule or standard regulating conduct in the workplace. So they're going to ask you, where is your rules? Did he contravene one of the rules? Secondly, was the employee aware of that rule? Did you tell him about it? Thirdly, do you consistently apply this rule? Or can Mary come late every single day and now the one time John is late you want to dismiss him? So do you apply it consistently? If you create an expectation that people can get away with it, then other people can take you to the CCMA if you dismiss them for the same reason. Then they're going to ask you, is dismissal appropriate? Or should you have given a warning first? Maybe you've already given 10 warnings, then dismissal is appropriate. And lastly, they'll look at the employee's circumstances as well. How long has he worked there? What is his previous record? What is his personal circumstances? Because maybe something's going on in his personal life that led to this misconduct. Procedural fairness. How can you make sure that your procedure is fair? You have to conduct an investigation. You have to. There should be a disciplinary hearing. You should get evidence regarding this. You should be able to prove that you did an investigation. You need to notify the employee and give the employee time to state their case, to give evidence to the contrary. They can also have a representative if they want to. Afterwards, if you decide to still dismiss him, you should communicate that decision to the employee, and the penalty should be applied consistently. As we said, you cannot dismiss John for one thing and keep Mary on for the same thing. It does not work like that. Some examples of misconduct. One of your most serious forms is dishonesty, and that will warrant a dismissal. You can immediately dismiss someone if they were dishonest, because it breaks your relationship of trust. So it's things like theft. If they steal, first offense, dismiss them. Follow your procedure, have an investigation, get all the evidence, but dismiss them. Because otherwise someone else is going to steal and they're going to stay on because you forgave Susan when she stole something. Fraud, immediate dismissal, but go through your process. Do the hearing, do the investigation. Willful damage to property, willfully endangering others, physical assault, gross insubordination, definitely first-time dismissal. Then we have participation in an unprotected strike is also seen as misconduct. However, that's something that does not warrant immediate dismissal. You have to consider how serious was the contravention of this act. Did they make attempts to comply with this act? Did they try and get a protected strike? Did they try and get a legal strike, but they couldn't? And was the strike in response to unjustified conduct by the employer? So there's a few things you have to consider before just dismissing someone for taking part in a strike. Otherwise, they can take you to the CCMA. So lastly, to note about misconduct, only acts of misconduct that are sufficiently serious, such as theft or fraud, are dismissible offences, or where they repeat the same misconduct. This person is constantly late every single day. He constantly mouths off towards seniors every single day. You have given him warning upon warning upon warning. You have tried to give him training to get him to act better. He just does not. Then you can dismiss him. Discipline should be progressive. First give a verbal warning, then a written warning, then a final warning. It is not sufficient to simply give a notice. To say, here's your notice, you have to go, goodbye. Fairness is judged on a case-by-case basis. So of course they look at the case individually, what was the circumstances. However, it is advised that you adopt a written disciplinary code to say this is how we're going to treat you, this is what we're going to do if you do commit misconduct. The next one, dismissal due to incapacity. What does incapacity mean? It's an inability to perform your job functions properly in accordance with the standards required, or unable to perform your job functions because you are sick, or incompatibility. You are incompatible with your employer or fellow employees. You cannot work together. No one likes you, or you don't like anyone else. You rub them up the wrong way. That will all be seen as incapacity. Please note that this is not misconduct. If you dismiss someone due to poor performance, it is not misconduct, because misconduct is a deliberate act. So unless they are deliberately not doing their work, it's not misconduct. They just can't. They don't have the capacity to do their work. So this is a no-fault dismissal. It's not that person's fault. Maybe he doesn't have the capacity. Maybe he's not smart enough. Maybe he doesn't have the qualifications. So you will treat this one really with a bit more delicacy than you will treat dismissal for misconduct. You want to require counseling. You want to give this person some training in order to increase his proficiency, to become better. Now the things they will consider is, number one, whether the employee met the required performance standard. So you set a standard. Did he meet it, yes or no? If they did not, Was the employee aware of the standard? Was the employee given a fair opportunity to meet the standard? Did you give him training? Did you give him counseling? Did you try and help him to meet the standard? And is dismissal an appropriate sanction? Or could you have placed him in another position where he might have met the required standard? So what do you need to do? What is the procedures? Inform the employee of his deficiency. And you need proof of this deficient performance. So you need to show that you did an assessment of this person, or in some or other way you try to show him that he's not performing properly. Did you give the employee guidance to rectify the issue? Did you give him training? Did you give him an opportunity to rise to the occasion, to do better? Did you consider any alternatives? Maybe to put him in a less stressed or less qualified position? But dismissal should be the very, very last resort. And if you did not go through these procedures, if you didn't give this person training, if you didn't try and put him in another position, then he has a case at the CCMA. Some factors that you need to consider: the position of the employee. Of course, the more senior the employee is, if he doesn't perform, then maybe you won't go through all the procedures because you had certain requirements when you appointed that person. If he can't meet the requirements, well, then you'll have to get someone else. The standard of work required, the degree of seriousness of the failure to perform, the length of that person's service. If he's worked for you for 10 years, you can't now suddenly say he's not getting up to standards, because then maybe your standards suddenly got too high. Past record of this person, if there's any possibility of additional training or possibility of transferring the employee. So that's a few of the things that you will look at before dismissing this person. Then if we look at ill health, incapacity due to ill health, now you might be sick, and that injury or that ill health might be temporary or it might be permanent. And due to that sickness, you cannot do your work either as you did before, or you cannot do your work at all. But before you dismiss someone like this, you need to investigate the extent of the incapacity or injury, and if there's any alternatives. For example, if I'm now paralyzed, I got in an accident, I'm now paralyzed, can you give me another job to do where maybe I don't need to walk as much? Because it's not my fault now that I'm paralyzed. Don't just dismiss someone immediately. Try and see if there's any alternatives. But what if I have cancer? I'm sick at home, I'm lying in bed, I can't move. Well, then of course you'll have to dismiss this person because it's permanent. They cannot do their job. The employee, however, will be allowed to state their case, and you should consider the degree of the incapacity. Is rehabilitation possible? Was the injury caused on the job? If the injury was caused on the job, then the responsibility on the employer is really a lot higher to try and find an alternative. So a few things they will consider at the CCMA. Is the employee capable of performing the work? And if not, to which extent? To which extent can he perform the work? And can his duties be adapted? Can you help him to still be able to keep his job? Or lastly, is there any other suitable alternative work? And then if you look at incompatibility, in and of itself, it's a legal reason for dismissal. It's not in terms of the act, but in the absence of statutory guidance, case after case has confirmed the old principle that the employer is entitled to require harmonious working relationships in the organization. So the principle was developed to say that if there's an inability to work harmoniously, you can dismiss this person. It can either go under incapacity dismissal, but you'll have to still follow the same procedures. See if you cannot rehabilitate this person. See if you can't put them in another position, another suitable position, anything like that. Or you can do it under retrenchment, to say it's for operational reasons that this person is being dismissed, but then you'll have to go through the retrenchment procedures. Let's then look at the procedures for retrenchment, the operational requirements. This is if you need to dismiss people based on the economic, technological, or structural needs of the company. So maybe financially the company is not doing so great and you have to dismiss people. Or you're getting a new machine that's replacing 10 people's job and you need to dismiss them. Or you're restructuring your business and you need to dismiss them. This is also no-fault dismissals, and there are specific obligations on an employer, such as trying to find alternatives to dismissal, exploring alternatives with the employees, and if they have to be dismissed, to treat them fairly. So let's look at the procedure to follow if you're going to retrench people. Number one, you have to consult with the employees. You have to let them know, listen, I have to retrench people. For financial reasons, for technological reasons, I have to retrench people. Let's talk about this. Let's see if we can find alternatives. Let's see if we can come to some sort of agreement. You have to consult with the workplace forum if there is one, with any person in terms of a collective agreement, with any trade union if there is one, or alternatively with the actual employees. So the moment you contemplate retrenchment, you have to let them know through a notice, Section 189 notice, and say, let's consult, let's talk about this. Then you have to reach consensus. You have to reach consensus on appropriate measures to perhaps avoid dismissal, to minimize the number of dismissals. Maybe they want to cut their working time, or maybe they'll cut their salary, to change the timing of dismissals, or to mitigate the adverse effects of the dismissals. You also have to reach consensus on the method for selecting the employees to be dismissed, who will be dismissed, usually first in, first out, and the severance pay. Of course, the severance pay, we start on 1 week for every year that you work there. It can go higher, however. The employer have to disclose certain things, the reason for the proposed dismissal, any alternatives considered, and the reasons why you rejected them. So you have to keep record. Listen, we consulted on this. This is the alternatives we considered, but it was rejected, and why. The number of employees that will be dismissed, the method for selecting the employees, first in, first out, when the dismissals will take effect, what is the severance pay that you will pay out, any assistance you might give to the employees who will be dismissed, and is there an agreement of possible re-employment in the future. Please note, if there is an agreement of re-employment in the future and you do not re-employ those people, it is seen as a dismissal. If you employ other people, without first re-employing the retrenched people, it is seen as a dismissal. Now you have to select the employers according to selected criteria agreed upon by everyone, and that is fair and objective. What is the generally accepted criteria? Length of service. Those who came in last goes out first. Last in, first out. And then you can also do it on skills and qualifications. So yes, the last person I appointed is the most highly qualified. I need this person. I cannot let him go. So one of the other people will have to go. In terms of severance pay, as we said, you start at 1 week's remuneration for each completed year. That's the minimum. And if your employee refuses to accept alternative employment, so let's say they tell you you can either be retrenched or you can be employed. We've got you employment with another company for the same salary, for the same benefits, everything, and they refuse it unreasonably, then you do not have to pay severance pay. If you do not dismiss employees in terms of those 3 conditions and those 3 procedures, it will be seen as unfair dismissal. However, there are some dismissals that is automatically unfair. Immediately automatically unfair. If your employee participated in a supported or protected strike, unless they are guilty of misconduct, if you dismiss them for being part of a strike, it's immediately unfair dismissal. If there is a strike and you want them to do the work that a striking employee should have done, and they refuse to do that work, and you dismiss them, automatically unfair. A refusal by an employee to accept a demand in respect of any matter of mutual interest between them and their employee, and you dismiss them. If he took any action by exercising any right in this act or participating in any proceedings in terms of this act, so if he exercised any right in terms of the Labor Relations Act or participated in any strike, and you dismiss him. If you dismiss them due to a pregnancy, if you unfairly discriminate and dismiss them based on discrimination, if you transfer the business and they cannot keep their work after the transfer. So you sell the business to someone else, or you transfer the business to new premises, or someone else takes over the business and now suddenly they don't have their job anymore. Or if you dismiss them because they took action in terms of the Protected Disclosures Act, blowing the whistle, Protected Disclosures Act, and you dismiss them based on that. These are all automatically unfair, immediately. It is also, as we said now, unfair if you cannot prove a reason, one of the three reasons, either misconduct, capacity, or operational requirements, and you didn't do a fair procedure. You didn't follow the procedures that we looked at now. It will, however, be a fair dismissal if you dismiss someone due to the inherent requirements of a job. For instance, you needed a qualified doctor. Maybe this person lied and said he is a qualified doctor, and then you realize that he's not. It's a fair dismissal. And lastly, based on age, if that person has reached the agreed retirement age, then that person retires, then it's not a dismissal. Please note, however, where you have created an expectation for employees that they can stay on after retirement. For instance, your retirement age is 60 years of age, but other employees stay on until 70. And you dismiss a person at the age of 60 and you say he has to retire. He can take you to the CCMA because he can say that there's a reasonable expectation for him to stay on after retirement age. So don't fall into that pitfall. Then what is unfair labor practices? Well, an unfair labor practice is any unfair conduct by the employer relating to promotion, demotion, probation, training, or benefits. Any unfair suspension, any failure or refusal to reinstate or re-employ a former employer in terms of an agreement, any occupational detriment other than a dismissal in contravention of the Protected Disclosures Act. That will all be seen as unfair labor practices. If we look at probation, you cannot use probation to deprive employees of the status of permanent employment. So you cannot say, I employ you for a probation period of 6 months, and then before the 6 months is up, tell this person he didn't make the cut, and then fire them. You need a proper reason for dismissing someone within the probation period. The period should be determined in advance, and it should be of a reasonable duration, so that person should know that he's working for a probation period. You should also give an employee reasonable evaluation, instruction, training, guidance, or counseling for that person to render satisfactory service. So if you don't like him within the probation period, you have to make sure that you give him instruction and guidance. If the performance is below standard, you have to advise him, and you have to give him reasonable time in which to up his performance. So you can extend the probationary period if you want to. If, of course, he doesn't live up to standards, you are allowed to dismiss within the probation period, but you still need to do this in terms of a proper procedure. So please do not think that a probation period takes away the fair procedure. They can still take you to the CCMA if you do not dismiss them in terms of a fair procedure in the probation period. If you have a dispute, if there's a problem, you think that a dismissal was unfair, you can refer it to a council or to the commission. This referral must be made within 30 days of the date of dismissal or within 30 days of the employer making a final decision to dismiss an employee. If it was an unfair labor practice, you have 90 days to refer it to the CCMA, or 90 days from the date of which you became aware of that unfair labor practice. If you are retrenched, you can and you dispute that, you feel that they didn't do it in terms of a proper procedure or a proper process, you can refer that dispute to arbitration or to the labor court. If the employer followed a consultation procedure that applied to that employee, if the employer's operational requirements led to dismissal of that employee, and if the employer employs less than 10 employees. So then you can go to the labor court. You can also refer a dispute to the labor court for adjudication if the employee allege that the employee has been subjected to an occupational detriment for having made a protected disclosures as in the Protection Disclosures Act. As we said right at the beginning, the onus of dismissal is always on the employee. The employee should always prove that he was dismissed, and then if he can prove that, the employer has to prove that the process was fair. In terms of remedies, what can they do if they find that the dismissal was unfair? How can they help you? They can order reinstatement, so they can tell you, or they can make you go back to work, order re-employment, or order a payment of compensation. Mostly people opt for the payment of compensation because you can just think about it. If you were dismissed now, you don't want to go back to that person. You don't wish to go back to be reinstated. Or if you were dismissed for misconduct, the employer doesn't really want you back. The relationship will be intolerable. The only reason why you won the CCMA case is because they didn't follow a fair procedure. So yes, you are guilty of theft. You are guilty of misconduct. But you won because they didn't follow a fair procedure. In that case, of course, they will order a payment of compensation. They won't say reinstatement because you're just going to steal again. What's the compensation amount? Compensation awarded for unfair dismissal other than automatically unfair. So unfair dismissal where they didn't follow the correct procedure, or they didn't dismiss you for a substantive reason, can be up to 12 months remuneration. For automatically unfair, it can be up to 24 months of remuneration. So all your automatically unfair dismissals, you can get up to 24 months remuneration. And then if you get compensated for an unfair labor practice, that can be up to 12 months remuneration. We say up to, it can be less. Then let's quickly look at a new act that came into effect in August 2015, 9th of August 2015, the Employment Services Act. What the Employment Services Act plans to do, well already doing, is to establish productivity within South Africa, decrease unemployment, and provide training for unskilled workers. How do they do that? Well, they have established a public employment service. If you go and look at the website, I think the website is ESSA, Public Employment Service, which is then managed by the state. And this public employment service provides state assistance to unemployed job seekers. They help you to register. They help to search for placement opportunities for you. They provide training for you, to upskill you, to help you to get access to a career. And then they also require certain employers in certain industries to register their vacancies. So register these vacancies on their website, and then they link the unemployed people to the vacancy, and they send that unemployed person then for interviews. And then as employer, you are required to take them for an interview. However, you don't need to appoint them. If they are the best candidate, of course you will, but you have to take them for an interview. So in that way, they are then helping unemployed people to get jobs. Currently, they are funded by the Unemployment Fund. the UIF. The next one we're going to look at is the Tax Administration Act and the changes that came about in terms of the Tax Administration Act in this year. Firstly, let's look at a few statistics. In terms of the Tax Ombud, the Tax Ombudsman received about 6,003 contacts during the year, of which 1,277 were complaints. 409 of these complaints fell within their mandate. Unfortunately, only 409. Some of them did not. And then of this 409, 75% were finalized in favor of the taxpayers. So at least the taxpayers in the end won the complaints. Of course, the cases which fell outside their mandate prematurely sent to the Ombudsman before the taxpayer exhausted all the SARS complaints resolution mechanisms. Your alternative dispute resolutions, all of those. They rejected 861 complaints, which they said this is not complaints, they rejected it. What falls outside their mandate? Unfortunately, what can they not do? They cannot review legislation or tax policy. So unfortunately, you can't go to them and complain about the legislation and say the legislation needs to change. They can't do anything about SARS policy or a practice generally prevailing. They cannot review any matter subject to objection and appeal under a tax act. And they cannot make a decision of a proceeding in or matter before the tax court. If the tax ombud does make a recommendation, that recommendation unfortunately is not binding on the taxpayer or on SARS. So SARS can turn around and say they do not want to listen to the tax ombud, unfortunately. So just a bit of statistics. Let's then look at the most serious issues identified by the tax ombud, the most serious problems that they had to deal with. Withdrawal of assessments, unintended tax debts arose due to patent errors being made on returns either by SARS or by the taxpayers. So what happened was that the time frame in which the taxpayer could dispute prescribed, and the only avenue really left to them was to withdraw the assessments. Secondly, delayed payment of refunds due to taxpayers. Why did this happen? Due to audits, due to people not updating their banking details, things like that. So they did have some delayed payments. Failure by SARS to update banking details. So you would go and update it with SARS, but they didn't update it timeously. SARS not adhering to turnaround times for objections and appeals. Yes, unfortunately, there's a general disregard with SARS with regards to time frames. However, on the other side, taxpayers need to comply with the time frames. So we are aware of that. Outcomes of objections and appeals were incorrectly implemented. They failed to assist or respond to certain taxpayers. Debt procedures were not adhered to by debt collectors. SARS taking too long to finalize tax clearance certificates. And then SARS e-filing fraud. That were some of the most serious offences identified at the Ombudsman. So let's look at the changes that came in this year. The first one is the new payment method. Please note that no longer will you be able to make any manual form of payment at any SARS office. Won't be able to queue, there's no payment queue, there's no checks, there's no posts, nothing. The only way you can do it is electronically or at your bank. And you can only do it at your bank for checks of up to 50,000 Rand. If you want to lodge a complaint, forms should be completed either via e-filing or by calling the SARS Complaints Management Office. So no paper copy of the complaint form, and the complaint will only be accepted if there is already a case logged and the case number is inserted on the form. So you already have a case, you already started a dispute resolution or some other case. The resolution of that case then will be a maximum of 21 days after the complaint was logged. In terms of the illegal use of the word SARS, I'm sure you all are aware of this. No person may use the name or abbreviated name of SARS, use any logo or design of SARS, falsely represent any material or substance as emanating from SARS, use any name or description which implies some association between them and SARS, or register or use a domain name which incorporates the name of SARS. No changes there. Still illegal to use the word SARS. In terms of requests for relevant information, SARS is allowed to require from a taxpayer or any other person to, within a reasonable period, submit relevant information. And then the changes that came in, if the material is held by a connected person located outside the Republic, within 90 days from the date of the request, they need to then give the information over to SARS. If the taxpayer fails to provide the material that is held by a connected person to SARS, then they cannot later try and produce that information in any subsequent proceedings. So if later they want to dispute anything with SARS, they can't come now with the documentations because earlier you couldn't provide it. How do you suddenly have it now? In terms of interviewing individuals, a SARS official may, by notice, require any person, whether or not they are chargeable to tax, whether they are an employee, whether they hold an office in a business, in a company, they can ask any person by notice to come for an interview. If the interview, of course, is intended to clarify issues of concern to SARS, such as to render further verification or audit unnecessary, to expedite a current verification or audit, or if the interview is not for purposes of a criminal investigation. Where SARS goes and do field work or a criminal investigation at the premises of a person, the person on whose premises that audit or criminal investigation is carried out on, and any other person on the premises must provide reasonable assistance to SARS. So SARS can ask any person, not only the person whose premises they are on, any person on that premises to assist them. You cannot refuse, you cannot obstruct that investigation. They can also ask you to provide information under oath or solemn declaration, and then you still have your constitutional rights. If, in terms of an investigation, SARS feels that you have not complied with the Act, so they already feel there is non-compliance, there is a problem, there is a criminal offense that occurred, then they can get an inquiry order. So a judge can then grant an inquiry order to SARS if they are happy that a person has failed to comply with an obligation imposed under a tax act, that person has already committed an offense, that person has disposed of or removed or concealed assets in terms of outstanding tax debt, and that relevant material will be revealed during the inquiry to provide proof to that fact. So if they already feel that there's a criminal offense, they can get an inquiry order for you. However, you have the right to have representation if that does happen. So you can bring your own representation. In terms of reduced assessments, no changes there. SARS can make a reduced assessment if the taxpayer successfully disputed the assessment, if it's necessary to give effect to a settlement, necessary to give effect to a judgment pursuant to an appeal, and there is no right of further appeal. There's a readily apparent undisputed error in the assessment, or the assessment was based on the failure to submit a return, a processing error by SARS, or a return fraudulently submitted by a person not authorized by the taxpayer. And they can do this despite the fact that an objection has been lodged or no objection has been lodged. they can make a reduced assessment if they wish to do so. Then they have changed the regulation in terms of the period of limitation for issuance of assessment, because what happened was that taxpayers would delay their information. They would delay to give all the relevant material to SARS, and then in the end the period will prescribe, or whatever the fact may be, or they just wanted to drag this out as long as possible. So the commissioner may now extend a prescription period. So where you are deliberately trying to drag out the proceedings of SARS to get your tax matter to prescribe, to not be able to pay, the commissioner can now extend the prescription period. He can extend it by a period approximate to the delay. So to say, I think the delay will take a year, so I'm going to extend it by a year. Or he can delay it by 3 years if the assessment was done by SARS, or by 2 years in the case of a self-assessment. So basically the Commission now has the right to extend a prescription period. In terms of third-party appointment, so what happened is if you do not pay your tax, SARS can go to your employer and they can appoint your employer as an agent, then if you want to call it that, for SARS to get their tax directly from your salary. And then they will take off the amount from your salary. So before you actually get your salary, SARS will take off the tax due to them. They cannot automatically do it anymore. So now they have to give a taxpayer 10 days. They have to give a notice to the taxpayer to say, listen, we are going to do this. We are going to get your employer to pay your tax. Give him notice of 10 days, and then the taxpayer at least has some time to sort out his things, to maybe try and come to an agreement with SARS, to maybe find the money somewhere to be able to pay SARS, to do something to be able to rectify the situation so that the money doesn't come off directly from his salary. In terms of getting a refund from SARS and interest on the refund, of course SARS have to pay a refund, including interest, if they took too long to pay the refund. If that amount is reflected on an assessment, or if you pay too much to begin with. You pay too much tax due to an error on your assessment. However, SARS can delay the refund if they have to do an audit, if they have to do a verification. So they can delay the refund, and then if they delay the refund due to verification or an audit that needs to be performed, they can also hold back the interest. Then they're not going to pay you the interest. Of course, if they pay you too much, if they refund you too much, then you have to pay it back to SARS. So it will then be an outstanding tax debt on your assessment, and next time when you do your tax, you will see the money in there. In terms of evasion of tax or getting undue refunds due to fraud or theft, if you do this with intent to evade tax or assist another person to evade tax, then you are guilty of an offense. Upon conviction, you will be subject to a fine. You can go to prison for 5 years. So if you make any statement, give a false answer, whether orally or in writing, prepares false books of accounts, makes use of fraud, makes any false statement, anything like that, unless you can prove that there is a reasonable possibility that you were ignorant of the falsity of the statement, you will be regarded as being aware of the falsity of the statement and held liable to a fine or imprisonment. In terms of delivery of documents, nothing much changed here. The only thing that is extra is that very last sentence, that SARS can deliver documents to you via e-filing. So they can hand it to you in person, they can send it to your place of residence, send it to your email, send it to your telefax, or they can put it on e-file. So very important, they can send notifications and letters to e-filing, and if you do not actually go onto e-filing and check up, you won't see them. So important to log into e-filing on a regular basis and just check whether or not they sent any documents, any communication to your e-filing page. That then is the changes in terms of the Tax Administration Act. Let's look at the last few things. Forthcoming attractions. The Community Schemes Ombud Services Act. Now the Community Schemes Ombud Services Act itself is already there. It already exists. It became effective, if I'm not mistaken, in 2014. However, they have new draft regulations for this act. What is the Community Schemes Ombud Services Act? Well, they created an ombudsman for you to go and complain to should you have any issues with your neighbors, should you have any issues with your body corporate that you can't sort out, maybe you have a cat scratching your vehicle that doesn't want to stop, anything like that. So then you can go to the ombudsman and you can complain. They already have a website if you want to go and look at that, all up and running. However, they want to change the regulations because currently there's no funding for this ombudsman. They need funding. Where will this funding come from? Well, they want to put a levy on all community scheme unit owners. Community schemes such as your sectional titles, your share block companies, your homeowners associations, property owners associations, housing schemes, housing cooperatives. So for all of those, they will all be affected, whereby a levy will be paid annually. Every community scheme will pay that levy to the Ombud Service, and they can then charge that levy back from the unit owners. This levy must be paid before the 30th of September each calendar year with interest on late payment. Please note this hasn't been commenced yet. It's not effective yet. Something we are looking forward to. You can be exempt from paying that levy if you are an individual within a community scheme with a property value not exceeding 500,000 Rand. So if your property does not exceed 500,000 Rand, your levy will be 0 Rand. The levies are not a lot. It increases a bit. For 600,000, I think you start at 3 Rand per month on a levy, and then it goes to 6 Rand per month, 10 Rand, so on and so forth. The highest you can pay is for a property value of 2.5 million, and it is 67 Rand a month. 67. That's the most you can pay over and above, of course, your normal levy for this Ombuds Service levy. The big thing about this, I think, will be education. Not a lot of people will know about the amounts, and then you might get some body corporates who will charge more than they are allowed to charge. The second exemption is if your household income, your net monthly household income is less than 5,500 Rand. Then you also don't have to pay this levy. And any other person who does not qualify for those two levies can go to the Chief Ombud and apply for exemption and see if they can get it. The second thing they want to implement through these regulations is for community schemes to take out insurance. a type of fidelity insurance against the risk of loss of money belonging to the community scheme. So over their bank account, over their levies. The minimum amount of that insurance, they plan to make it the community scheme's investments and reserves at year end. So whatever cash they have left at year end, plus 25% of their operational budget for the current financial year. So if someone commits fraud and runs away with the money, at least they have somewhere to claim it back from. And lastly, they will have to give a copy of their financial statements to the Ombudsman. They will have to file that before the 31st of October each year. I really think that this is a good act. It's a good thing that you can go somewhere to complain, because sometimes the dispute resolution procedures in terms of a body corporate and these community schemes doesn't really work. And they need to be funded somehow. They need to be funded. So we need those levies. The next forthcoming attraction that you have to look forward to is the Labour Laws Amendment Bill. I'm quite happy about this. I really like this amendment. And this bill will provide for paternity leave for fathers. Currently, what do we have? We have maternity leave for your mommies. When they are expectant, they then get 4 months from the birth of a child to then take leave in terms of your Basic Conditions of Employment Act. However, the father doesn't get anything. For the father, you must take your 3 family responsibility leave days. And then later, if something happens and you need those leave days, you don't have them anymore. So there has really been a call from fathers to get proper paternity leave, to be able to bond with their children, and to not interfere with their other leave. So they have this bill now. It's not effective yet. I really hope it becomes effective quite soon, where fathers will get 10 consecutive days paternal leave when the child is born. So when your child is born, you'll get 10 consecutive days. So if you work Monday to Friday, that is 2 weeks. It's quite nice. If you adopt a child, once again, currently there's nothing in our labor legislation to give you maternity leave if you adopt a child. So if you adopt a child under the age of 2 years, then this bill will provide for parental leave. They don't call it maternity, they call it parental leave. Remember, a dad can also adopt a child. Parental leave of 10 weeks, 2.5 months. And then the other parent, of course, if there's 2 parents, the other parent can get the 10 days leave. So one parent gets 10 weeks, one parent gets 10 days. If you're a commissioning parent in a surrogate motherhood, then you can also qualify for the 10 weeks parental leave and 10 days paternal leave for the other parent. The family responsibility leave will then no longer need to be taken, and you can take that for other reasons. And then the last forthcoming attraction is King 4 that we have to look forward to for next year. Currently they are in phase 3 of finalizing the King Code. They have an expected effective date of mid-2017. So they really want to get it effective by mid-2017. Now, big changes happening in King 4. What changes? Well, they want to make it a more practical, principle-based code, because currently it follows a rule-based approach. They have about 75 rules in there that you have to comply with. They want to change that to an outcome-based, where they will take the 75 rules and consolidate them into 16 principles and link them to outcomes, to say this is the actual outcome that we are trying to achieve. This is how you can get to that outcome. So they will give you recommended practices to be able to get to that outcome. So they really want to make the King Code more applicable over a broader range of companies rather than just for your large companies that are currently using it. They want to make it more accessible to your smaller companies, your non-profit companies, your private entities, your municipalities, all of those types of companies. Problem is that they're going to change it from an apply or explain to an apply and explain, which means that you have to apply the king code now and you have to explain how you are applying the king code. Unfortunately, we don't have time to go through the changes, the actual changes in the king code. So you might want to go and read through it and familiarize yourself with exactly how they are changing, how the principles are changing, and how that will impact you. They did release some sector supplements together with the King Code to help your small and medium enterprises, your public sector entities, your municipalities, your pension funds, and your non-profit organizations in terms of implementing King Code in their business. So it is recommended that you do not read the King Code in isolation, but that you read it together with a sector supplement to see exactly how you will then be able to implement the new and improved King Code in your business. And then the last thing we're going to look at, other important notices, is the additional voluntary disclosure program for foreign exchange. The reason for this new and special additional voluntary disclosure program is because of the new global standard for automatic exchange of information between tax authorities that will commence in 2070. So it might happen that from next year on, SARS will get your information, your offshore information, so much easier, and they will be able to see where you are trying to evade tax, where you are taking income offshore and not paying tax on it. Now this is a joint operation between SARS and the South African Reserve Bank. On the one hand side, you have the voluntary disclosure, the SARS voluntary disclosure, where you disclose income, undisclosed previous income. And on the other hand, you have your South African Reserve Bank disclosure, where you disclose contraventions with the exchange control. They are going to do this for a period of 6 months. It already started the 1st of October 2016, whereby you can then for 6 months voluntarily disclose your transgressions basically to SARS and to the Reserve Bank to say, please don't give me a big penalty, and then you'll get a reduced penalty. Who can apply? Only individuals and companies. Unfortunately, offshore trusts will not qualify. If you are a settler, donor, deceased estate or beneficiary of a foreign discretionary trust, then you can elect to have the offshore assets deemed to be held in your name, and then you can apply in your name for this voluntary disclosure program. So let's quickly look at the tax relief available in terms of the SARS disclosure side. So where you are going to disclose previously undisclosed income. So let's say you had undisclosed income between 1st of March 2010 and 28th of February 2015, and you took it offshore to acquire assets offshore in order to hide it from SARS. You can now come to SARS and say, listen, I did this. This was my undisclosed income. And then they will not include the undisclosed income in your tax. They will only include 50% of the value of the assets in your taxable income. What that means, however, is that if you bought the asset for 10,000 Rand and the asset is now worth 30,000 Rand, you can see how 50% of the asset will be more than the actual income. So if that is the case, maybe you want to venture into our other voluntary disclosure options and not look at this one. If you do decide to use this one, you have to calculate the 50% of the assets in a specific way. How do you need to calculate it? Well, you need to take the market value of the assets as it is currently, so the market value of the assets currently, translated at a spot rate. But that spot rate that you have to use is not the current spot rate. It's the spot rate at the end of the period in which the assets had the highest value. So you will go and have to draw up an Excel spreadsheet to say between 1st of March 2010 and 28th of Feb 2015, what was the value of the assets, in which year was the value the most, and take the spot rate in that year times by the current market value in that offshore currency. So you can see that if the spot rate was higher in that year, it might be worse for you. If it was lower, it might be a good thing for you. If you use this voluntary disclosure, then you do not need to include your undeclared income into your taxable income. You also do not need to pay an understatement penalty. You will not be held liable for criminal prosecution. And you will not need to pay any donations tax, capital gains tax, or estate duty on that income. Please note, however, that this voluntary disclosure does not apply to VAT, it does not apply to pay as you earn, to SDL or UIF. Those type of taxes have their own voluntary disclosure program. This is only for income tax. And then the disclosure part for the South African Reserve Bank. What do you need to tell them? What do you need to disclose to them? This is for contraventions in terms of exchange control. Please note, if you contravene any exchange control regulation, if you have assets offshore that you're not supposed to have there in terms of an exchange control regulation, and they find you before you voluntarily disclose this, the penalty is 100% of the value of the assets. That's why you do not want to pay the penalty. You would rather want to disclose this. So, who is it available to? Individuals and companies for all your exchange control contraventions prior to 29th Feb 2016. It is not available if you are already being investigated for exchange control contraventions. So if you're already being investigated by FinServ, you will not qualify for this. If you do go and voluntarily disclose this, what will you then have to pay? What is the penalty that you will have to pay? You will have to pay a levy based on the market value of the offshore asset as at 29th of Feb 2016. That levy can either be 5%, 7%, 10%, or 12%. It is 5% if the assets are brought back to South Africa. It is 10% if the assets are kept offshore. However, you have to pay this levy from foreign funds. You have to source this levy from foreign funds. If you can't, if you have to pay it with local funds, then 2% is added to that levy, which means that the levy can then increase to 7% or 12%. And then lastly, you cannot use any unutilized portion of your foreign capital allowance to reduce the value of the assets or the levy you have to pay. Unfortunately not. That then brings us to the end of our session. Thank you very much for joining me for this legislation update. If there's any questions, I will be available. Please do ask them. Otherwise, enjoy the rest of your day and thank you very much.